Welcome again to the continuation of lectures for Persons and Family Relations Law. Our topic for today is surnames. Okay, as you all know, surname is indicates lineage. It indicates our descent, the family, the clan where we came from. Okay, now surname, the use of surname is actually one of the offshoots or consequences of filiation. Okay, so once filiation has been established, the right to use the surname is a necessary consequence. Okay, so the topic for today will teach us the laws and pertinent cases on the right on the surnames that legitimated children, adopted children should use. Okay, as well as the relevant jurisprudence on the matter. Okay, Article 364 tells us that legitimate and legitimated children shall principally use the surname of the father. Okay, why the surname of the father? As I have said, okay, surnames indicate descent, okay, lineage, the clan, okay, where you came from. Okay, and the father being the principal head of the family, okay, the offsprings or the issues or the children of that person who is the father, okay, shall carry principally his surname. Why principally? As we will learn later on, the word principally, okay, carries an interpretation which can give the child the option to also use the surname of the mother if he or she chooses to. Okay. How about an adopted child? An adopted child shall bear the surname of the adopted. Okay, usually in adoption, okay, the law requires a joint petition filed by both mother and father. Okay, but whoever is the adopter, whether it is the mother or the father, the adopter will give to the adopted child his or her surname. How about illegitimate children? Article 368 tells us that illegitimate children shall bear the surname of the mother. Okay? Uh, Remember the words shall bear. So it is mandatory, shall bear the surname of the mother. Okay? However, under the Revelia law, if the father of the illegitimate child has acknowledged the child as his own, okay, he also that child shall also have the right to carry or bear the surname of the father. Okay? Article 369 tells us that children conceived before the decree annulling avoidable marriage shall principally use the surname of the father. So notwithstanding that there is a decree annulling avoidable marriage, the children conceived, okay, during such marriage shall use the surname of the father. Okay. How about with respect to married women? What surname should they use? Okay, Article 370 tells us a married woman may use, remember the word may. So it is permissive. Her maiden first name and surname and add her husband's surname. Ito yung mga tinatawag na hyphenated women. Okay? So you continue to use your maiden first name and maiden surname. Why? Because it is the family. It is actually your family, your blood lineage. Okay? And then you just add to it with a hyphen the surname of your husband to indicate that you are already married. Okay? Because the surname of the husband indicates your civil status, while your first name and surname indicates your lineage. Okay? Second, her maiden first name and her husband's surname. So you your middle initial would be your surname when you are still a maiden. Okay? So you just use your husband's surname as your surname. Okay? Number three, her husband's full name, but prefixing a word indicating that she is his wife. Okay? So, for example, Mrs. Juan de la Cruz. Okay? So, only the full name of the husband is used. Okay? Uh, so in any of those instances, okay, the wife, once she gets married, the female, once she gets married, can choose between any of the options provided under Article 370 of the Family Code. Article 371, in case of annulment of marriage and the wife is the guilty party, she shall resume her maiden name and surname. If she is the innocent spouse, she may resume her maiden name and surname. However, she may choose to continue employing her former husband's surname unless the court decrees otherwise, or she or the former husband is married again to another person. So if she is the innocent wife, she can continue unless either of them is married to another person. Okay, how about in legal separation? When legal separation is granted, the wife shall continue using her name and surname employed before the legal separation. So the wife may revert to her maiden name and surname. How about a widow? What surname shall the widow use? Can she revert back to her old maiden name? Or can she continue using her husband's surname? Okay, Article 373 provides a widow may use the deceased husband's surname as though he were still living. Okay, so, but it is actually the option of the widow whether to still continue using her husband's surname or to revert back to her maiden name and surname. In case of identity of names and surnames, the younger person shall be obliged to use such additional name or surname as will avoid confusion. Okay, this is very popular in the Philippines when usually the fathers would name their children, their male children, especially junior or the third or the second, and so on and so forth. So you have to add a an extension, okay, of the name to identify that person from the ones which is older than him, okay, from which his or her name was taken. Okay, in case of identity of names and surnames between ascendants and descendants, the word junior can be used only by a son. Grandsons and other direct male descendants shall either add a middle name or the mother's surname or add the Roman numerals 2, 3, and so on. Okay? There is also a requirement in the law that for you to be able to change your name or surname, you have to get court approval. Okay? Usurpation of a name and surname may be the subject of an action for damages and other relief. The unauthorized or unlawful use of another person's surname gives a right of action to the latter. How about with respect to celebrities or actors and actresses who are employing stage names, screen names? Okay, Article 379 states that the employment of pen names or stage names is permitted provided it is done in good faith and there is no injury to third person. Pen names and stage names cannot be usurped. Okay? There is also a prohibition on the use of different names and surnames. Okay, so a person is known by only one name. Okay, you cannot use different names unless you're using it only as a screen name, as a pen name, or a stage name. Okay, the first case in the matter of the adoption of Stephanie Garcia. The issue in this case is, may an illegitimate child, upon the adoption by her natural father, use the surname of her natural mother as her middle name. So we have here a case wherein there is an illegitimate child, okay, who is, and her father, the biological father, is already married to another person. Okay, now the biological father wants to adopt the child to elevate the status of the child to his legitimate child. Okay, now can that child, because when you're adopted, okay, you adopt the surname of your adopter. Okay, however, if she adopts the surname of her father, she will have no middle name. Now, can that child use also the surname of her biological father? Okay, the Supreme Court said, Honorato, the petitioner, filed a petition to adopt his minor illegitimate child, Stephanie. Stephanie's middle name, Astorga, be changed to Garcia, her mother's surname, and that her surname, Garcia, be changed to Katindig, his father's surname. Okay. The Supreme Court said a man's name is the designation by which he is known and called in the community in which he lives and is best known. It is defined as the word or combination of words by which a person is distinguished from other individuals. It is both of personal as well as of public interest that every person must have a name. So the name has two parts, the given or proper name and the surname or family name. The given or proper name is that which is given to the individual at birth or at baptism to distinguish him from other individuals. The surname or family name is that which identifies the family to which he belongs and is continued from parent to child. The given name may be freely selected, but the surname to which the child is entitled is fixed by law. The law is silent as to what middle name an adopted may use. An adopted child shall bear the surname of the adopter. The adopted shall bear, again, it is silent whether he can use a middle name. What it only expressly allows as a matter of right is for the adoptee to bear the surname of the adopter. So Stephanie, in this case, is entitled to all the rights provided by law to a legitimate child without discrimination of any kind, including the right to bear the surname of her father and her mother. Since there is no law prohibiting an illegitimate child adopted by her natural father to use as middle name her mother's surname, we find no reason why she should not be allowed to do so. Although under the law, okay, it is required that the father and the mother adopt jointly, okay, or the spouses pala to adopt jointly so that there will be no problem with respect to the middle name. But in this case, considering that it is only the father, the biological father, who adopted the illegitimate child to elevate her status to a legitimate child, okay, that child can use the surname of her biological mother as her middle name and the surname of the father as her surname. Okay, Yasin versus Sharia District Court. Okay, when there is already a divorce, is there a need to file a petition in court for the wife to revert back to her maiden name? Okay, that issue is answered in the case of Yasin. Okay, in this case, Yasin filed a petition for the use of her maiden name on the ground that there is already a divorce under Islamic laws and that her former husband is already married to another woman. So the issue is whether or not in the case of annulment of marriage or divorce under the code of Muslim laws, and the husband is married again to another woman, and the former desires to resume her maiden name, is she required to file a petition for change of name? The Supreme Court said the use of the husband's surname during the marriage, after the annulment of marriage, and after the death of the husband is permissive and not obligatory. You're not even obliged, even during the marriage, to use the surname of your husband. Okay, the word may is used indicating that the use of the husband's surname by the wife is permissive rather than obligatory. We have no law which provides that the wife will change her name to that of the husband upon marriage. This is in consonance with the principle that surnames indicate descent. It is therefore, it seems therefore that a married woman may use only her maiden name and surname. She has an option, but not a duty to use the surname of the husband. Okay, so remember, for those who are still single, okay, you don't have the obligation to use the surname of your husband. It is permissive, meaning it is optional. It entirely depends upon you if you want to use the surname of your husband in accordance with Article 370 of the Civil Code. But if you do not want to use it and you want to stay, okay, using your maiden name and surname, okay, you may do so because surnames indicate descent. Okay, the appellation or the annexation of the surname of your husband to your name indicates only your civil status and not your descent or lineage. Okay? When a woman marries a man, she need not apply or seek judicial authority to use the husband's name by prefixing the word Mrs. before her husband's full name or by adding her husband's surname to her maiden first name. The law grants her such right when the marriage ties no longer exist, as in the case of death or divorce. The widow or divorcee need not seek judicial confirmation of the change in her civil status in order to revert to her maiden name, as the use of her former husband's surname is optional and not obligatory. When petitioner married her husband, she did not change her name but only her civil status. Neither was she required to secure judicial authority to use the surname of her husband after the marriage, as no law requires it. We find the petition to resume the use of maiden name filed by the petitioner as a superfluity and unnecessary proceeding. Okay, so when you get married, you don't have the obligation to use your husband's surname. You can continue using your maiden name and surname. Or if you want so that the public can recognize that you're already married, you can append your husband's surname as a and add it to your maiden name and surname. Okay. When you get a divorce under the Muslim personal laws, or when your marriage is annulled or declared void ab initio, there is no need to file a petition in court for a change of name, so such that you can revert back to the use of your maiden name and surname. Okay? Remo versus Secretary of Foreign Affairs. So this is a case involving the reversion to the use of the maiden name and surname of a married person in the passport. Okay. So She has changed her name. Okay, she has used her husband's surname in the passport, and then later on, she wants to revert back to the use of her maiden name without the husband having died or the marriage having declared annulled or annulity. Okay. So that is the issue that was resolved in the case of Remo. Okay. The issue is whether petitioner who originally used her husband's surname in her expired passport can revert to the use of her maiden name in the replacement passport despite the subsistence of her marriage. In this case, the Supreme Court said the use of the word may indicates that the use of the husband's surname by the wife is permissive rather than obligatory. So it reiterated the ruling in the case of Yasin. Clearly, a married woman has an option but not a duty to use the surname of the husband. She is therefore allowed to use not only any of the three names provided in Article 370, but also her maiden name upon marriage. She is not prohibited from continuously using her maiden name once she is married, because when a woman marries, she does not change her name but only her civil status. Further, this interpretation is in consonance with the principle that surnames indicate descent. Okay. In recognition of this right, the DFA allows a married woman who applies for a passport for the first time to use her maiden name. Such an applicant is not required to adopt her husband's surname. In the case of renewal of passport, a married woman may either adopt her husband's surname or continuously use her maiden name. If she chooses to adopt her husband's surname in her new passport, the DFA additionally requires the submission of her marriage certificate. Otherwise, if she prefers to continue using her maiden name, she may still do so. The DFA will not prohibit her from continuously using her maiden name. However, once a married woman opted to adopt her husband's surname in her passport, she may not revert to the use of her maiden name unless there is death of the husband, divorce, annulment, or nullity of marriage. A married woman's reversion to the use of her maiden name must be based only on the severance of the marriage. Nothing prevent if we allow the petitioner's request, nothing prevents her in the future from requesting to revert to the use of her husband's surname. Okay? As a result, undue confusion and inconsistency will result. Thus, for passport issuance purposes, a married woman whose marriage subsists may not change her family name at will. Okay? So, with respect to issuances of passports, once you use your husband's name in the passport, you cannot later on revert back to your maiden name unless your husband has already died or there is severance of the marriage vinculum, such as divorce, annulment, or nullity of the marriage. Okay, we now move to the case of Copuaco versus Republic. So Dolores and Vincent Ko, a Chinese national, were married. They were blessed with 5 children, all surnamed Copuaco. Now, Vincent Ko left the conjugal abode and has never returned, and he was declared an absentee. So the husband abandoned his family. Now, Dolores contracted another marriage with Padilla. So the 5 minor children were generously supported by Padilla. Now, Dolores filed a petition for the change of her children's surname from Copuaco or Co to Padilla, okay, which was granted by the court. Okay. Now the issue is that considered as a valid ground for a change of name? Okay, the Supreme Court said to allow the minors to adopt the surname of their mother's second husband, who is not their father, could result in confusion in their paternity. It could also create the suspicion that said minors who were born during the coverture of their mother with her first husband were in fact sired by Padilla, thus bringing their legitimate status into discredit. Okay. So that is not actually a valid ground for a change of name. Okay, why? Because it could create confusion on the lineage, descent, or paternity of the minor children. Guligado versus Republic. The issue in this case is whether or not the person adopted can use the surname of the husband's adopter even if the latter has not joined her in the adoption. Okay. The Supreme Court answered this question in the negative. To allow the minor to adopt the surname of the husband of the adopter would mislead the public into believing that she has also been adopted by the husband, which is not the case. So the husband's consent to the adoption might be presented to prove that he has actually joined the adoption. So remember, in cases of adoption, the adopted child shall use the surname of the adopter. So in this case, the husband has not joined the wife in the adoption. So the child is only entitled to use the surname of the wife as his surname, but the child cannot use the surname of the husband, okay, as his surname. Okay, why? Because the husband has not joined in the adoption. Okay. We have the case of Tolentino versus Court of Appeals. This is a case, can a divorced wife continue to use the surname of the husband? So kabaligtaran ito ng Yasin because in Yasin, he wanted to get rid of her husband's surname. So in the case of Tolentino, a divorced wife wanted to continue using her husband's surname. Diba in the case of annulment or declaration of nullity, once the either spouse has already entered into another marriage, the former wife or the former spouse can no longer use the or continue to use the surname of her former husband. So in the case of Tolentino, the issue is whether or not a divorced woman may continue using the surname of her former husband. Okay. Remember that we have no provisions for divorce in our laws. Consequently, the use of surnames by a divorced wife is not provided for in our laws. Only with respect to annulment or declaration of nullity of marriage. Okay, so in this case, the Supreme Court said the wife cannot claim an exclusive right to use the husband's surname. She cannot be prevented from using it, but neither can she restrain others from using it. So the effect of divorce is more akin to the death of the spouse, where the deceased woman continues to be referred to as the missus of her husband, even if the latter has remarried, rather than to annulment, since in the latter case, it is as if there had been no marriage at all. In this case, there is no usurpation of the petitioner's name and surname, so that the surname of Tolentino by the private respondent cannot be said to have injured the petitioner's rights. Okay. In fact, it is of public knowledge that Constancia is the legal wife of Arturo, so that all invitations for the senator and Mrs. Tolentino are sent to Constancia. Consuelo never represented herself after the divorce as Mrs. Arturo Tolentino, but simply as Mrs. Consuelo David Tolentino. The private respondent has legitimate children, have every right to use the surname Tolentino. So it was not the mere use of the surname that was enjoined, but the dependent's representation that she was the wife of Saturnino. We rule, therefore, that the use of the surname Tolentino does not impinge on the rights of the petitioner. So, unlike annulment and declaration of nullity, the Supreme Court said that a divorced wife may continue to use her former husband's surname even if the former husband has already remarried. So, it is more akin to that of the widow, okay, wherein the widow is allowed to continue using the husband's surname. Republic versus Abadilla. So Gerson and Luz Biminda have been living together without the benefit of marriage. So during their cohabitation, they begot 2 children. However, in their certificates of live birth, it was made to appear that they were married. Thus, the children were registered with the surname Abadilla. Okay. An amended petition for correction, cancellation of entries in the certificate of live birth of the children was filed to delete the date and place of marriage because they were not really married. Okay. So the trial court committed reversible error when it allowed the deletion of the date and place of marriage in the certificates of live birth of the minors, but failed to order the change of the minor's surname from Abadilla to Celestino. Remember, during the time that this case happened, the Revilla law is not yet taken effect. So thus, as illegitimate children, Emerson and Rafael should bear the surname of their mother, Celestino. Okay, but under the present time, considering that the Revilla law has already took effect, the children, as long as they are acknowledged by their father in the certificate of live birth, can use the surname of their father. Okay, Santos versus Republic. In this case, Francis filed a petition for the change of name under Rule 103 to change his surname from Santos to Revilla. Okay. Uh, he is the child of Lovely and Bong Revilla, legitimate child. So with respect to illegitimate children, they will use the surname of the mother. So the petitioner's certificate of live birth did not bear the Revilla surname as his father was marked as unknown. However, Bong Revilla later executed an affidavit of acknowledgement recognizing his paternity of Francis. Lovely married Patrick Santos, who in turn legally adopted Francis. Thus, petitioner's name was changed from Francis Guzman to Francis Santos. However, this Francis grew up close to his father, Bong Revilla. So he filed this petition in order to avoid confusion to show his desire to associate himself to Bong Revilla. Okay. The Supreme Court said, upon issuance of the decree of adoption, the change of the adoptee's surname shall follow that of the adopter as a natural and necessary consequence of a grant of adoption, even if not prayed for. He remains to be the legitimate son of Patrick Santos by virtue of the adoption. The latter and not the former is his true legal identity. Remember that a sincere desire to associate oneself to a certain person does not justify a change of surname. Okay, so the Supreme Court did not sustain his contention that he wants to associate himself to his true biological father. Why? Because there is a legal adoption that has already been granted. So, pursuant to the law, he is mandated to use the surname of his adopter. Now go to the final case, Alanis versus Court of Appeal. Okay. Does a child have the man have the option to use the surname of his mother even though he is a legitimate child? Okay, that question was answered in the case of Alanis versus Puerto Rico. Okay. Pursuant to the state's declared policy of ensuring the fundamental equality of women and men, a legitimate child is entitled to use the surname of either parent as a last name. Okay. So in this case, Mario Alanis and Jarmila Balyaho, uh, the petitioner, the parents of the petitioner were Mario Alanis and Jarmila Balyaho. The name on his birth certificate was Anacleto Balyaho Alanis III. However, he wished to remove his father's surname, Alanis III, and use his mother's surname because he has been using his mother's surname, Balyaho, in his school records and since childhood. So the RTC naturally denied the petition. Now the issue is whether or not legitimate children have the right to use their mother's surname as their surnames. Okay, so the Supreme Court used the fundamental equality of women and men as justification for giving the legitimate child the option to choose whether to use the surname of the father or to use the surname of the mother. Remember that Article 174 provides legitimate children shall have the right to bear, shall principally use the surname of the father. Okay, so the word principally. So the RTC's application of Article 364 is incorrect. The provision states that legitimate children shall principally use the surname of the father, but principally does not mean exclusively. Okay? There is no legal obstacle if a legitimate or legitimated child should choose to use the surname of its mother to which it is equally entitled. But I want you to think of the ruling in Alanis. Okay, remember in the previous cases, in the case of Yasin, and in the previous cases that we have already discussed, the Supreme Court has reiterated uh, the doctrine that surnames indicate descent. It indicates lineage or ties. So, but if the child would have the option to use only the surname of the mother, wouldn't that have an impact on the indication of descent, of lineage, of blood relationship? Because if it would only reflect half of that blood relationship, wouldn't we be sacrificing uh, the true intention of surnames, which is to indicate descent, to the just sacrificing the true intent of having surnames. So only to justify the equality between women and men. So if we will only use the surname of the mother, then it would not indicate his true descent, the child's true descent or lineage. Instead, it would only indicate half of it. Okay, so that is one thing that we should ponder or we should think about. Okay, so with that, I am ending the discussion on use of surnames. Thank you for listening.